Danny McDow, or is that correct?
That's correct, Your Honor.
Okay. Ms. Medina, while we're waiting on information for Devontae Williams, can we proceed with Danny McDowell?
Yes, Your Honor.
Okay. All right. Where is Mr. McDowell?
He's right here, Your Honor.
Okay. All right. Officer, are you going to be conducting probable cause hearing? You going to swear to it?
Yes, Your Honor.
Okay. All right. Saturday, July 15th, 2023, 1:10 p.m. in the matter of People State of Michigan versus Danny Eugene McDowell, charged with count 1, assault with intent to murder, count 2, torture, count 3, criminal sexual conduct, first degree, during felony, count 4, unlawful imprisonment, count 5, criminal sexual conduct, third degree force or coercion, count 6, assault with intent to do great bodily harm less than murder or by strangulation, count 7, domestic violence. Officer, state your name for the record.
Detective Christopher Wilder, Plymouth Township Police Department.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Will you be testifying based on personal knowledge and or information?
First, it'll be investigation, so after the fact.
Okay, investigative report, correct?
Correct.
All right, proceed.
So Plymouth Township Police Department responded to 12811 Heritage Drive, apartment 203 on 7/13 at 3:58 in the afternoon for a welfare check on a victim. Take a step back, sir. Good. Once they arrived, they contacted the defendant who's in custody, Danny McDowell, and the victim, Faith Allen, at the residence. After speaking with both of them for some time, they were separated. Assault was determined that it happened. McDowell was placed under arrest for domestic. He was transported back to the station. I, as the detective on call, was sent out to the scene, conducted field investigation, conducted interviews. Was found to believe that on Tuesday, a couple of days prior, so it would have been 7/11, assault occurred, including 3 different times where the suspect placed the victim underwater, held her underwater, and at one point on the 3rd assault actually drowned her to the point that she lost consciousness. Once she woke back up, she went to the bedroom.
All this occurred on the same day?
This was over 3 days, Your Honor.
Over a 3-day period?
Yes, Your Honor.
Okay, go ahead.
So on 7/11, that's when the 3 drownings occurred. 3rd one, she passed out, was no longer conscious when she woke up. She went back to the bedroom. The defendant forced her to perform oral sex on her at that time, or on him at that time. The assault stopped at that point. After he fell asleep the next morning, he slapped her a couple times, which would have been on the 12th. Nothing else occurred on the 12th. We approached to the 13th. The 2 of them had consensual sex at that point on the 13th, after which he threatened to have her fill up the bathtub a second time, to which she was able to reach out to a colleague to call 911, and that's how the police department got involved in the matter.
Okay, what was the torture involved? Was that the strangulation or whatever?
I believe, Your Honor, that's what the prosecutor's office determined to be torture.
Okay. All right. It looks like mental pain or suffering or whatever. All this occurred in the Plymouth, Michigan?
Yes, sir. Plymouth Township.
Plymouth Township. Okay, stand corrected. All right. The court is satisfied that probable cause has been established. And we'll proceed directly to the arraignment. Ms. Medina.
Crystal Medina, Your Honor, on behalf of Mr. McDowell, with regard to the arraignment, we would waive formal reading and stand mute, Your Honor.
Yes.
Okay, Mr. McDowell, state your name for the record.
Danny McDow, Danny Eugene McDow.
Okay, thank you. Mr. McDowell, your attorney having waived the formal reading of the complaint and warrant, the court will enter a not guilty plea in this matter. Argument as to bond, please.
Your Honor, at this time, so We did have the opportunity to speak with Mr. McDowell. I do understand that these are very serious allegations, Your Honor. However, I would ask the court to consider that at this time, they are just that, allegations. Mr. McDowell disputes these allegations, Your Honor. He looks forward to coming to court and addressing the allegations that have been made against him. Mr. McDowell indicates that he is able to stay with his mother at his mother's home on Deacon Street in Detroit, Michigan. He indicates that he understands he is to have no contact with the complainant or with her address, Your Honor. He is 36 years old. He is not currently on probation or parole. While we do see that he has a criminal history, a felony, a previous felony conviction, it was back in 2006, Your Honor, and that was for an unarmed robbery, Your Honor. He indicates that he drives for Uber. His monthly income varies, but given his variable monthly income and his expenses, he is not able to post a monetary bond at this time, Your Honor. And so I would ask that the court, he also receives food stamps, Judge. So that means he is under the guidelines. And we would ask that the court consider giving him an opportunity to come to court and address these allegations, Judge. He is a lifelong resident of Michigan, if I didn't mention that already, Your Honor.
All right, thank you. Officer, you have any comments or thoughts as to bond?
Just running due to the serious nature of these crimes and the fact that we believe that he's a safety risk to the public, we're asking for a high cash bond, at least $250,000, if not higher. If you do decide to release him, I'd at least ask that he be on a GPS tether, have no contact with the victim, not be allowed to live at the victim's house, not be on any kind of alcohol, drugs, anything like that. So to be testing for that kind of thing, and then be in contact with either probation or somebody so that we can kind of monitor what's going on with him. But again, just due to the seriousness of the crimes and our fear for the victim's safety at this point, if he does get released. He did mention during when we were having him process that don't worry, none of the victims are going to come here to testify. So again, we're worried about the safety.
Come on, man. You don't lie like that, man.
Okay.
You don't have no evidence, man. You're just taking her word for it. You're just taking her word for it. You don't have no evidence, Your Honor. And I did not say that. I said they're not going to come because it's not true.
Mr. McDowell, you have the right to remain silent. I would strongly suggest you exercise your right.
Thank you very much, Your Honor. If I may, because again, that commentary is likely to invoke a response from my client, right? Again, Your Honor, that comment, if made, could have been made for several reasons. One can take it as a negative way, or it could be taken as they lied from the beginning, and so they're not going to come to court and lie under oath, Your Honor.
Exactly.
So I would ask that
Mr. McDowell.
I'm sorry, I'm sorry, sir. This emotional moment.
Mr. Medina, hold on one second.
I'm sorry, McDowell. I'm just emotional right now, man.
It's one thing.
I'm sorry. I'm just emotional.
Are you going to be quiet?
Go ahead.
Mr. McDowell.
Yes, sir.
You not only interrupted the court, you interrupted your attorney. And he said she's trying to help you.
I know, sir. It's just, I'm sorry.
Okay. Now, I want you to step aside and be quiet for the remainder of this hearing, okay?
Yes, sir.
Thank you.
Thank you, Your Honor. And so I do think, again, if that comment was made, it could have been made for various reasons, Your Honor. And so I would ask that the court consider that these are verbal allegations that are being made at this time, and that my client has lifelong ties here, and that his previous conviction was back in 2006, Your Honor, and that somehow after 3 days there was access to there's a lot to be flushed through here in the facts, Your Honor. Okay. And so I would ask that my client be given the opportunity to come to court and do just that. He understands he's having no contact with the complainant, and I would ask that the court consider all of that, Your Honor.
All right. Thank you, Ms. Medina. The court, having heard representations of the attorney and the officer on this matter, what is very, very troubling and is indicative that Mr. McDowell cannot control his emotions and impulsive were just demonstrated. And he admitted he's very, very emotional. He responded disrespectfully not only to me, to the court, but to his attorney, and who's acting in his best interest. And so, given his demonstrated impulsiveness, the court's going to adopt the recommendation of the officer $250,000 cash surety bond, no 10%. If he's able to post that bond, no contact with Faith Allen and no contact with the Heritage Drive.
Let's take a moment to understand the legal framework behind what just happened, because the judge's decision wasn't random and it wasn't purely punitive. Under Michigan law, when setting bond, a judge must consider several factors: the seriousness of the offense, the defendant's criminal history, their ties to the community, their flight risk, and critically, their danger to the public and to witnesses. The detective had already flagged that Danny allegedly said the victims wouldn't testify. That comment alone, whether intended as a threat or not, raised a witness intimidation red flag. Then Danny demonstrated in open court that he cannot regulate his behavior under pressure. He interrupted the judge. He interrupted his own attorney. He escalated even after multiple warnings. The judge explicitly cited this impulsiveness in his ruling. He didn't raise the bond to be cruel. He raised it because he watched a man facing 7 felony charges prove in real time that he is incapable of compliance. The $1 million bond isn't a punishment for speaking out. It's a judicial determination that this man cannot be trusted to behave in public and that Faith Allen's safety requires it.
Apartment located in Plymouth, Michigan. Your probable cause conference date is July 27th, 9 a.m. at 35th District Court. The preliminary examination date is August 3rd, 9 a.m. Just to be clear, and just to clarify the court's ruling, the court deems Mr. McDowell a safety to the community, a safety to the community witness in this matter, and given his extended emotional outburst before the court just now, the court is...
If he's trying to give me life, why wouldn't I be? He trying to give me life. He don't have no evidence, sir. Why wouldn't I be? He trying to give me life. Man, shut up talking to me, because you trying to give me life, man. And you know it's not true. And you know it's not true. Why wouldn't I be emotional? He trying to give me life. He ain't got no evidence on none of this. And he's acting for $250,000 bond. What's wrong with him, man? He don't even got no evidence. Who's touching me, man? You ain't got no evidence. Of course I'll be emotional, man.
Sorry, Your Honor.
He's got me a $250,000 bond with no evidence. Yeah, I'm emotional.
Are you taking a bath?
Go ahead, Steve. Okay, the court's going to change the bond to $500,000.
Wow, sir, you can change to $500,000. He's still lying. He don't have no evidence. Now it's $500,000. Make it $1 million. It don't matter. I can't post $250,000.
Okay, I'll make it $1 million then.
I can't post none of it anyway.
Okay, sir, step aside. This concludes the hearing.
Okay, Your Honor, so the final amount for the bond?
$1 million.
And is that
Cash surety.
He's seen all that shit on her wall, and he ain't taking none of that evidence down, man. I know what he's trying to do, man.
Your Honor, he was put back in a cell. I'm sorry about that, Your Honor.
Okay, no problem. That concludes the hearing. Thank you,
Your Honor.
officer.
Thank you, Your Honor.
Let's bring this home. On July 15, 2023, Danny Eugene McDow appeared before the 35th District Court in Plymouth, Michigan, for arraignment on 7 felony charges, including attempted murder, torture, 2 counts of criminal sexual conduct, unlawful imprisonment, assault with intent to cause great bodily harm, and domestic violence. The alleged victim, Faith Allen, reportedly endured 3 days of abuse beginning July 11th, including being held underwater 3 times, losing consciousness on the 3rd, and being forced into a sex act immediately after. Detective Christopher Wilder testified under oath that McDow made a statement during processing suggesting the victims would not appear to testify, a claim McDow denied explosively and repeatedly in open court. Defense attorney Crystal Medina made a competent, professional bond argument, citing community ties, no current supervision, a dated prior conviction, and her client's financial limitations. But those arguments were overtaken by events. McDow's own behavior, his repeated outbursts, his inability to stay silent even after direct warnings from the judge sealed his fate. Bond started at $250,000. It ended at $1 million. Probable cause conference, July 27th. Preliminary examination, August 3rd. The broader lesson here, no matter how strong your defense is, how skilled your attorney is, or how convinced you are of your own innocence, a courtroom is not the place to make your case from the gallery. Your attorney speaks for you. The moment you override them, you become your own worst enemy. If this breakdown gave you a deeper look into how courtroom decisions are actually made, the legal reasoning, the human drama, and the moments that change everything, then do us a favor. Hit that like button, drop your thoughts in the comments below. We want to know, did the judge make the right call? And make sure you subscribe so you never miss another courtroom breakdown. We cover the cases that matter, the moments that shock, and the legal truths behind the headlines. See you in the next one.